They say City broke the rules, paying Mancini more than his contract dues. But it says nowhere you can't pay him more. You know where you can stick your PSR. Where was Yaya Touré's cake? His agent complained on every day. Every year it was the same. You haven't sung him happy birthday again.
In this video, we are going to walk you through the Manchester City PSR Premier League case. So that this will be easier to follow, we have created a series of supporting videos. These will go into much more detail about what we are saying and why. Firstly, we will provide a list of facts and base what we say on those facts. Secondly, we will talk about legal principles and laws which affect this case. Laws are called acts in England, or acts of parliament. Thirdly, we will provide a case summary, so you can see what this is actually all about. We will highlight key issues which will affect the outcome. Then we will focus on 3 of the 5 allegations. We believe there is enough information in the facts we have identified to show that these 3 allegations cannot be proven by the Premier League. We have no real knowledge about the other 2 allegations and will only touch on them briefly. However, the 3 allegations we discuss are sufficient to destroy the Premier League case. We will show consistent unfair treatment towards Manchester City by the Premier League. This could be used by City's lawyers to argue this case is an abuse of process, vexatious and malicious. This can lead to significant compensation for Manchester City. Are you ready to begin? If you want to understand what the Man City case is all about, we need to look at the facts that have been published. They are the original Der Spiegel article, published in 2018, the CAS report, the Premier League statement, released on 6th of February 2023, a follow-up article by Der Spiegel in April 2023, the Premier League handbooks, Manchester City's financial accounts.
Several English laws apply, such as the Statute of Limitations Act, the Arbitration Act, the Civil Procedures Act, and the Third Parties Act. They all relate but basically mean the Premier League have to treat Manchester City fairly. This means fairly in a legal sense. The Statute of Limitations Act, which limits issues to 6 years. This puts a time limit on any action. The key date is the 5th of November 2018, as this is when Der Spiegel published their original article and the Premier League became aware of any potential wrongdoing. However, this only applies to new information. They are powerless to charge and punish City regarding anything they already knew about prior to 6 years before they charged City, i.e. that is the 6th February 2017. This could be significant for certain aspects of the case. The Arbitration Act, this sets out a process of how arbitration should be conducted. This means treating City fairly and also puts some limitations on what you can do. The Premier League hearing is a disciplinary panel, yet the Premier League rules state that arbitration can be used to overturn any disciplinary measures if they are not in line with the arbitration rules and the Arbitration Act. Rules X3 and X4. Similarly, if arbitration is not conducted lawfully, City could challenge any outcome in court. This is fairly robust and prevents the Premier League from conducting the case however they like. The Civil Procedures Act. This was introduced by Tony Blair and sets out clear rules on how these things should be done. It seems the Premier League might be in breach of these rules from the way they charge City in the first place. The Third Parties Act. This is a piece of common law that basically states only the 2 parties to a contract can enforce it. A third party cannot interfere, unless the contract explicitly gives them such powers. There are also several legal principles that are also at stake. Most notably is contra proferentem. This simply means that if any rule is ambiguous, it will be interpreted against the party that wrote it. This gives City an interesting advantage in some scenarios. In Manchester City's recent separate case against the Premier League's APT rules, it was ruled that the Premier League weren't treating City fairly. This could become an important factor in the PSR case. Furthermore, in the section of the rules called Relationships between the Clubs and the League, the following rule, B15, B16 states, in all matters and transactions relating to the league, each club shall behave towards each other with the utmost good faith. Utmost good faith is a legal doctrine which requires parties to fully disclose all material facts. We know City took Liverpool FC to court and settled out of court regarding directors of Liverpool FC hacking into City's scouting computer system. If a contract expressly imposes a duty of utmost good faith between the parties, then computer hacking by one party would constitute a breach of that duty. The act of hacking shows deliberate dishonesty and concealment, which is fundamentally incompatible with the concept of utmost good faith. Civil remedies could include termination, damages, or injunctions, in addition to any criminal liability. Hacking is therefore a serious breach of utmost good faith both substantially and procedurally. The Premier League failed to intervene or enforce this rule, despite the serious nature of the offense. City were subsequently forced to take Liverpool to court. Whatever the reason why, it's another example of the Premier League treating City unfairly.
Whilst you hear sensationalist headlines of 115 charges or 134 charges, these only relate to 5 different allegations or 5 things that the Premier League say City have done wrong. So let's take a look at the actual allegations. These 5 allegations tie together in 3 groups. Firstly, Allegation 1 is that City didn't earn as much money as they claimed from sponsorship deals, and in doing so falsified their accounts. Allegation 2 is that City paid a manager and a player more than was stipulated in their contract via third parties. So as a result, City's profit and loss statement is adversely affected.
The next 2 allegations are that this is so significant that City breached financial limits imposed by UEFA and the Premier League. Allegation 3. City no longer meet UEFA's FFP requirements. Allegation 4. City no longer meet the Premier League PSR requirements. Allegation 4 is pivotal to the whole case and must be proven. It is Allegation 4 that triggers the current disciplinary action. Finally, Allegation 5 is that City have not cooperated with the Premier League investigation. In any scenario, being charged for not cooperating is a signal that the charges are flaky at best. The very fact this charge has been made shows the low level of confidence the Premier League has in its own case. We will go through each of these 5 allegations and explain the actual rules that City are accused of breaking. What we will see is that in most of these cases, the rule breaches and allegations are tenuous at best.
The more observant of you will have already noted that the Premier League are powerless to enforce UEFA's rules, as this is a contract between UEFA and City. Therefore, Allegation 3 may be mute, and certainly nothing the Premier League can punish City for. It makes sense then that we start here with Allegation 3. Allegation 3 is that Manchester City violated UEFA's regulations over a 3-year period, specifically club licensing and FFP. The rules violated are B14.6 in 2013-14 and B15.6 during seasons 2014-15 to 2017-18. These rules all say the same thing. Membership of the league shall constitute an agreement between the league and the club, and each club to be bound by and comply with the statutes and regulations of UEFA.
City breached UEFA's FFP in its first year, 2014-2015. City were punished accordingly by UEFA. Why, when this was known almost 10 years ago, are the Premier League accusing City of breaking this rule now? This must surely be time-barred, if indeed the Premier League can punish City. As we've already noted, as a third party, the Premier League has no rights under the agreement between City and UEFA. We've also read through UEFA's rules, and the Premier League is not given any rights in these rules. This means they have no right to enforce UEFA's rules or even assess them. City can only be considered in breach of UEFA's rules if UEFA have investigated them with their investigation chamber and then charged them. Subsequently, the arbitration committee fined them guilty. This has happened and City were then cleared at CAS. What makes the Premier League think they can overrule this process and take things into their own hands?
However, this could be a massive own goal for the Premier League. It is yet another example, now the third we have highlighted, of the Premier League not treating City fairly. Why charge City for something they have no hope of enforcing? The evidence regarding unfair treatment is mounting. It is consistent, despite Premier League being legally obliged to treat City fairly. Why are they doing this?
These points indicate City will almost certainly be cleared of this allegation. Of all the rules City are being accused of breaking, this next allegation, allegation 4, is pivotal. City are accused of breaching rules E52 to E60 in 2015-16 and E53 to E60 in years 2016-17 and 2017-18. That's 25 rules in total.
When you read these rules, they form a process to assess PSR. Several of the steps are things the Premier League do, not City. So how City can have broken them is quite bemusing.
Of these rules, Rule E60 is also irrelevant. This only applies to clubs who have played in the Football League in the previous 3 years. How could City have broken this rule when they have only played in the Premier League during the period in question? The rule is simply irrelevant. It is another example of the Premier League sensationalizing City's wrongdoing and treating them unfairly.
It is Rule E59, however, which is important. This rule states the following. If a club has a PSR loss of over £105 million, then the club must be referred for disciplinary action under Section W. In other words, the entire disciplinary process, and this whole case was triggered because of City allegedly breaking PSR. Therefore, all of the punishments City can receive, except for non-cooperation, require the Premier League to prove City have breached PSR. This is by losing more than £105 million in the 3 relevant PSR.
We have done PSR the calculations for these 3 periods. We used the information in Manchester City's financial accounts, the Premier League rules, and then adjusted them to reflect this case. We assumed allegations 1 and 2 are proven to establish a worst-case scenario. We have shown these calculations in a separate video as they are too long to include here, in our worst-case scenario. In the 1 period, City might breach PSR. This is a smaller breach than those that Everton, twice, and Forest were punished for. Crucially, it is also less than Manchester United's breach last year, for which they were not punished.
Periods. Manchester City made good profits during the period in question, not losses. They also had significant allowances they can claim under AEBT. These are expenses that can be excluded from the PSR calculation. This is mainly for depreciation on the expansion of the South Stand and the building of the Etihad campus. It seems the Premier League has overlooked this. When you look at the sums involved in allegations 1 and 2, City should have no worries on this front. We have detailed these calculations in a separate video. It is a lot of maths. These calculations drive a sledgehammer through the entire case against City. In other words, if City are guilty of allegations 1 and 2, they still don't break PSR. This means there was no sporting advantage gained. This means no punishment can be applied. Allegation 2 is about salaries paid. This regards 1 player and 1 manager, whose salaries weren't disclosed properly in accordance with the rules.
The only manager City had on the dates mentioned indicate this must be Roberto Mancini. The Der Spiegel article in April 2023 backs this up, that it was Mancini, and also identifies Yaya Toure as the player. In both cases, the Der Spiegel article doesn't provide any real evidence to support these allegations. The emails they provide as evidence do not prove anything. Both have reasonable explanations too. The manager situation is easier to explain. Rule P8, or Q8 in other years, simply states that clauses in the appendices must be included in the contract. These clauses ensure managers do post-match interviews, they don't criticize referees, and so on. This rule and its related appendix says nothing at all about salaries. Charging City for breaking this rule is a complete red herring. Then, Rule P7, or Q7 in later years, states the Premier League must have a copy of the manager's contract. Presumably, this is so that they can check the clauses included in Rule P7 are included. That would seem logical. That is all these rules state, nothing else. Remuneration is not mentioned at all.
Now let's think about remuneration and contracts. Everyone who is employed under any contract will have received bonuses and pay rises. These are not stipulated in their contracts, nor are contracts updated to reflect any of these payments. It is not illegal to reward an employee by paying them more. Do you remember Manchester United winning the treble in 1999? Do you remember Alex Ferguson receiving a share in a racehorse called Rock of Gibraltar as recognition for this success? This share entitled him to winnings, entry to the owner's hospitality section, and winner's enclosure at major events. He also gained from the horse's stud rights. This was worth several £1,000,000. Were any questions raised about this as an illegal payment under Premier League rules? So why should City not pay Mancini more than his contract states? The rules around players are much more detailed, but similarly, there's no reason why City shouldn't pay them more either. The allegations for both state rules requiring clubs to include full details of player-manager remuneration in their contracts. The biggest issue here is that none of the rules quoted state this or anything that might suggest this. Since the rules don't say anything of the sort, it is going to be tough for the Premier League to prove this allegation is a breach of these rules. Even if the Premier League argue they do, contra proferentum applies in the situation, and their case will surely fail.
Has any other club had the rules twisted in such a way to try to punish them? It's also worth noting that the manager issue predates PSR, so has no relevance to it. So why bother with this charge?
There are lots of inconsistencies in this case. This is another form of unfairness. There are repeated changes in the charges. If we look at the Internet Archive, the Wayback Engine, we can see how the Premier League statement published on the 6th of February 2023 has been altered several times. The Wayback Engine shows us what it said on lots of different dates. At the very least, it is misleading to pretend the current statement purported to be published on the 6th of February 2023 is actually what was published. It is not. They have changed it. This is duplicitous. Furthermore, the Premier League statement conflicts with the analysis of charges done by Martin Ziegler. Now, Martin Ziegler actually broke the story before the Premier League announced it, so he must have been briefed in advance by the Premier League. This is a breach of due process under the Civil Procedures Act. Martin Ziegler states there are 115 charges, and this is where that number comes from. He categorizes the rule breaches. Only about 70 of them directly correlate with the Premier League statement. These two issues point towards shifting sands. In other words, the Premier League had not finalized their case before briefing Ziegler or announcing it publicly and then charging City.
So there are lots of things that are unfair from a legal perspective in the way the Premier League has treated Manchester City over the years.
1. Failing to sanction Liverpool for abusing City in the hacking case.
2. The APT ruling, where City were prevented from sealing lucrative sponsorship deals.
3. Publicly announcing the charges and briefing the media without pre-warning Manchester City. Both Everton and Forest were advised in advance.
4. The inconsistencies in the way the PSR case was started. Why can't they just do it properly?
5. Altering the statement published on the 6th of February 2023 numerous times.
6. Sensationalizing the City case compared to Forest and Everton cases surrounding PSR, trying to make it appear far worse.
7. The erroneous UEFA charge.
8. Charging City for breaking Rule E60.
9. The rules listed do not back up the allegations in Allegation 2. This is subverting the rules and a deliberate attempt to twist the meaning of them. Has the Premier League ever picked on another club like this?
10. Providing Manchester United with specialist allowances to try to help them comply with PSR.
These points are important because they are going to help City's case for compensation from the Premier League when they are cleared.
As you can see, Manchester City have been treated very unfairly over the years by the Premier League. The current PSR case also appears to be unsound. We are confident that based on the simple points we have raised by reading the rules and checking the available facts, that Manchester City will be completely cleared of these charges.
Please review our attached videos for more details about the information provided in this video. They back up what we say. We also provide background information about the convicted criminal Rui Pinto from Football Leaks. He is the original source of these allegations. The CAS report showed that one of the emails he supplied was two other original emails spliced together to suggest wrongdoing. Why would he do such a thing? We also reference the YouTube video from the British Virgin Islands that has created so much distrust of Manchester City in the eyes of rival supporters. This video was made at enormous expense and receives no revenue from YouTube because it is on a brand new channel. Why would someone in the British Virgin Islands do such a thing?
The only question that needs answering is why? We can guess at this too. Make no mistake, this is a conspiracy, and heads are going to roll.
Did Mancini get extra pay while he was away on holiday? By another firm in Abu Dhabi, genuine pay for consultancy. Where was Yaya Touré's cake? His agent complained on every day. Every year it was the same. You haven't sung him happy birthday again. Mancini was so long ago. You first said his money has to go. In the year that he was sacked before PSR, and that's a fact. Where was Yaya Touré's cake? His agent complained on every day. Every year it was the same. You haven't sung him happy birthday again. They say City broke the rules, paying Mancini more than his contract dues. But it says nowhere you can't pay him more. You know where you can stick your PSR. Where was Yaya Touré's cake? His agent complained on every day. Every year it was the same. You haven't sung him happy birthday again. Where was Yaya Touré's cake? His agent complained on every day. Every year it was the same. You haven't sung him happy birthday again.